Good evening, friends. And while there were vacations in Madras and Madurai, we thought, why not bring a speaker who can hammer his points, not only in the court, but also nail them in the right perspective so that you can understand things in the issue. Though the session's name today is Probable Defense and it pitfalls in the suits for specific performance of contract. But once we have Mr. K. Prabhkar, an advocate from Madurai Bench, Madras High Court, we know that all those pitfalls, if you have heard it, there won't be while you are drafting them and while you are arguing them, because he ensures that they are bulldozed properly, the road is smooth, and you can win it properly. And without taking much time, since we all know that it's a weekend and that too on a Sunday, and when vacations are about to end in down south, though our vacation will start in the month of June, I'll request straight away Mr. Prabhkar, we are waiting for your session, and show the defenses which can be all taken across. And we will share the notes given by Mr. Prabhkar on the website subsequently. We will convert it into a PPT of the previous webinar as well as this webinar. So do stay connected with us on the website and do subscribe to the channel of Beyond Law CLC so that you can see how knowledgefully Mr. Prabhkar shares his knowledge amongst with the host of other resource persons we try to bring from not only from India but pan world. Over to you, Mr. Prabhkar.
Thank you, Vikas. Good evening, my friends. The amendment to the Specific Relief Act 2018 makes it all the more difficult for a person to defend a suit for specific performance. Originally, there was Section 20, where all kinds of hardship can be taken into consideration. And in many cases where it has been pleaded or not, the court had the room or the leverage to dismiss the suit if he finds that there will be a hardship if a suit for specific performance is decreed in favor of the plaintiff. Once this Section 20 has been substituted by a new section and hardship has been almost taken away, the discretion which rests with the court is gone. A discretion which it could have exercised in favor of the defendant is no longer available. Then what is the scope available for a defendant to defend a suit for specific performance of an agreement of sale? The age-old defenses are manifold. We can say that one, that the agreement is not true, B, non-est factum, or there was no intention to execute the contract. 3, there was a loan transaction. 4, the plaintiff is not ready and willing. 5, the contract as put out by the plaintiff in the plaint is at variance with what has been agreed upon by the parties. These are some of the differences which are still available. If you take what are the differences available, one is under Section 16(2) and 3, second Section 17, Section 13, and Section 19, 21, and 22 with regard to the compensation and damages, as well as in case of an undivided interest in respect of a property. Now, well, first we'll take the ready and willingness is always read in conjunction with the time stipulated in the contract. If the contract stipulates some time, one is expected to perform within the time contemplated in the agreement, or soon thereafter he has to approach the court. But under Section 55 of the Contract Act, time is not the essence of the contract in case of an immovable property. If time is not the essence of the immovable essence of the contract, can a defendant come forward and say that notwithstanding the fact that he has come to the court within a period of 3 years, as contemplated in the Article 54 of the Limitation Act, the plaintiff should be non-suited because he is not ready and willing, notwithstanding the fact that the time is not the essence of the contract. As I have suggested the last Sunday, about AIR 1993 Supreme Court, a constitutional bench, wherein it has been held that there is a presumption that time is not the essence of the contract. There is also no presumption that time is not the essence of the contract. Therefore, once the constitutional bench, some 30 years ago, reiterated the principle as found in section 55, one would have expected that the time as contemplated in the contract is not the essence. A person can come to the court leisurely, but giving some explanation or justification for not coming to the court, still he can say that he is ready and willing to perform his part of the contract. But 4 years down the lane, if I remember, one of the judges who was in the Constitution bench authored another judgment reported in AIR 1997 Supreme Court page 1751, equivalent to 1997 3 SEC page 1, KS Vaidyanandam versus Vairavan, wherein the court said that even though section 55, or it doesn't say that, even though section 55 says that the time is not the essence of the contract, the law says the time can be made as an essence of the contract with the parties. Therefore, what has to be done is to look into the terms of the contract, whether the parties really intended that the time should be the essence of the contract. Terms of the contract are always got a role to play in interpretation of this type of contract. The intention in respect of urban property or a commercial property may be different from an intention to purchase an agricultural property. But what prompted the court, or one of the judges was a member of the Constitution bench in 1993, to have a different look in 1997. Maybe the opening up of the economy in somewhere 91, 92, rise in GDP, rise in income of the people, and then the sanctity of time contemplated in the agreement because they spurred the prices of the real estate market, boarded probably the judges in 1997 to have a real look. Even though the wording is not there in the judgment, they would say that the intention has to be gathered from the document and the conduct of the parties. And subsequently, there was another judgment in 2011, namely of His Lordship Ravindran in Saradamani Kandappan versus Rajalakshmi, AIR 2011 Supreme Court, page 3234. Equivalent 2011 12 SEC page 18, wherein His Lordship Ravindran would say that we should have a relook with regard to section 55 itself. What you would say that the law, once settled by the court, may not be good when the society changes after some years. That's what the Lordship would say, that after 1993, there was enormous change in the attitude of the people, change in the society, perception with regard to the property, the commercial attitude of the people. This all has to be taken into consideration. In fact, you would quote some judgments of the Supreme Court as well as the other Privy Council also, stating that in such a case, it's not necessary that we should be bound to the precedent. Rather, we should be aware of the reality, what is happening, and to temper the law according to this present day society. That is where you would say time can be construed in certain circumstances is the essence of the contract. That was the real turning point. And then after 2011, we can say that the courts have construed this ready and willingness in a much stricter way, in a sense. Even if you come to the court within 1 month, 2 months after the time period lapse, the court requires the party to prove his ready and willingness. Therefore, the first defense available in a suit for specific performance, insofar as the ready and willingness is concerned, time. Expose the time. If the plaintiff has not come to the court immediately, and if you feel that the agreement is true, of course, and you want to wriggle out of the contract, the one sure shot is to go before the court with all fairness, honesty, and integrity. That it is, I have entered into an agreement on certain circumstances. This man did not fulfill his obligation within the time contemplated. I was very serious about the time for the period from the time fixed in the contract or stipulated in the contract and the time when the plaintiff comes to the court. Makes a big case out of it. Took a magnifying glass and elaborate this as much as possible in the pleading and let in oral evidence and try to cross-examine the plaintiff why he has not come to the court immediately. Thereby, tried to expose the plaintiff that he could not have been ready and willing to perform his part of the contract. Therefore, my first submission is in a defense. Always possible because in many a case, as a lawyer practicing the trial court, nobody has come to the court the next day after the time stipulated the contract expires. It took some time. Therefore, you try to take advantage of this time. Magnify it manifold. Try to tell the court that this time is very vital and he should have followed it. He has not followed it. Therefore, he is not entitled to a degree for specific performance. I tell you that once this hardship is removed from section 20, it is always possible for the court or to convince the court rather that this ready and willingness, even though the government is not required, but proof is still required, this ready and willingness will play a major role. There will be a shift from the perception of the court, what has been done all these years and what will be done after the amendment in 2018. Therefore, once the court has been pushed to the wall, but they don't have the discretion which was available before 2018, and the court finds that the case, the plaintiff is not genuine in coming to the court a bit late or late, then it will try to exercise a discretion which was not available under section 20 by fitting in the case under section 16(3) in a much wider manner. Yeah, 2 months, 3 months time delay, which was glossed over all these years, probably will assume great significance after 2018. Therefore, try to take inspiration from Saradamani Kandappan's case of his Lordship Ravindran. Try to project if there is a delay. That is one of the sure way of defending a suit for specific performance. The second is, we all take into consideration, once an agreement has been filed into court by way of a suit for specific performance, we take the plea that it has not been executed by the defendant, or there was non-est factum that there was no intention, or the character of the document is different from what has been intended to be executed, or the consideration has not been passed, or the plaintiff has filled up the blank papers available with him. These are some of the defenses which you usually take. But when you try to take these types of defenses, be aware. Don't take some inconsistent pleas. Even though as a defendant, you are supposed to take inconsistent pleas, as many inconsistent pleas as possible. It is very difficult to convince a court if you try to shoot from all angles. Rather, pin down the plaintiff to a certain defense. When you are sure of one or two defenses which are not inconsistent and which will gel well with your overall defense, it is always better to take one or two plea and try to focus on such things. I have come across in a trial court a person denying the execution and then say that I have been forced or coerced to execute the document. Don't take this type of inconsistent pleas. The court will not believe, thinking that the defendant, after all, after executing the document, is trying to wriggle out of the contract by taking all types of pleas and sundries. If you are cocksure that you have not executed the contract, stick on to that. If your party feels that he has entered into a contract and this contract for some other reason ought not to be enforced in a court of law, then for certain reason, don't try to focus on the execution. Only when the execution can be, non-execution can be pleaded in cases where that the defendant or the vendor did not execute the contract. 2, he has been coerced to execute the document. 3, the blank papers have been filled up. In the first case, or the first, in case of an execution or the non-execution, the burden is always on the plaintiff to prove the contract. But in many cases, we find that the contract is proved in accordance with the law, because one of the witnesses always will be the witness of the or the ally of the plaintiff. He will come forward and depose. The difficulty after 2001 amendment of the civil procedure is this. Before 2001, the question of filing a chief affidavit by way of proof of chief examination was not possible. Therefore, when a witness is brought, when the counsel for the party cannot lead the witness, it is well nigh impossible for him to bring out the entire terms of the contract by asking him questions. The witness in many of the cases would blabber even in the chief examination. But unfortunately, that has now been watered down after the introduction of the chief affidavit, where the chief affidavits are drawn by the lawyer, and therefore there's no question of execution not being properly pleaded or deposed before the court. I have come across some of the cases where the courts have taken into consideration that in the chief he has spoken about the execution that ends the matter. At the other end of the spectrum, there are some judges who say that please don't touch the chief. The chief is all that the lawyers genuine or the ingenuity. Therefore, they go into the cross-examination, what has been stated by the witness. Even though the second part or the later part is more correct to assess the witness, the point for consideration is, once the affidavit has come into play, the burden of proving the execution of the document has almost vanished, because the proof, you would have covered everything. Unless if the witness is good enough, unless you are in a position to expose in the cross-examination, which in all cases may not be possible, if the execution of the document is denied, then the challenge can be made by punching a hole in the evidence of the witnesses, or by taking the evidence of an expert as a secondary evidence, which is also possible to compare the signature found in the document. At least in case of an unregistered document, a comparison with an expert will tilt the scale. Even though in some of the cases, including that of Punjab and Haryana High Court, I've said that even in case of an unregistered will, somewhere on judgment 1992 or 93 of the Punjab Haryana High Court, where there are two witnesses have been examined in case of a will, and an expert evidence came out with a different finding that the signature differs. The court said that the evidence of the witnesses are trustworthy and creditworthy. It is a primary evidence that has to be taken into account, and the evidence of the expert fails into insignificance because it is a secondary evidence. It cannot replace the primary evidence. Therefore, once you want to challenge the execution, you focus on execution. You focus on that you have signed the document blank paper. In two cases, then the second case, if you say that I have signed the document in blank, even though the execution has to be proved by the plaintiff, in one or two cases, it has also been stated in the Kerala High Court that if you affix your signature in a document, but stating that you have affixed the signature in a blank paper, then you have to explain your role or a conduct. How come you have put your signature in a blank paper? That becomes a well-nigh impossible as a defense to prove. Therefore, be careful. Unless and until you have got materials to suggest, namely the facts and circumstances, like in many cases where checks have been taken in a blank. The point is, once you admit the signature, there are two things you have to prove as a defendant. One is that you have signed it in a blank paper. The second is how the custody of the document went to the plaintiff. It's very difficult to, in certain circumstances, unless there is an exceptional case is made out. And therefore, be careful about taking such a plea unless you are cocksure. The third is fraud, undue influence, coercion, equivalent to duress, misrepresentation. These are some of the pleas available under Section 16, where you can bring in some material to show that you have never intended to execute the contract, you have been forced to do it, or the plaintiff has exercised an influence dominating your will, called as an undue influence, etc. Again, the problem is once you take the stand that the document has been executed by fraud, because there is the provision is there in the Specific Relief Act also, where if it is a variance or if there is a fraud, then Section 16B, where the fraud is also stated, you have the burden is upon the person who makes an allegation that it has been obtained by fraud or coercion. Once you take such a stand, the plaintiff will be relieved of the proving the execution of the document. The burden shifts to the defendant to show that it has been under certain circumstances, it has been obtained under fraud or coercion. Unless you have got a material, don't take such a plea. If you have got material, plead under Order 6 Rule 4 of the Civil Procedure Code. If you want to take a stand that the document has been obtained by fraud, you must plead the details of the fraud. What is the fraud committed? Merely a single sentence in the written statement that there is a fraud in executing the document may not be enough. The circumstances under which the fraud was committed. What was the fraud in any case? A fact which was known to the plaintiff or not known to you, and which has been suppressed, thinking that it is a fact that you have executed a document, but it was not a fact after all. These are the various arms of the definition of a fraud. Again, coercion. You are with the full conscience, you are signing the document, but under a threat or pressure from the other party. What is the pressure? What is the threat? Whether a police complaint was given immediately. What is your reaction after executing this document? These are things which you will have to plead in the written statement before ever you can take the stand forward before a court of law. The point is this. The point is this. It is a plea which has to be taken in the written statement. The next point is non-est factum. What is a non-est factum? Non-est factum always is an exception to section 92 of the Evidence Act. Fraud is an exception. Non-est factum or the character of the document, where I never intend to execute this type of a document. So long as these types of unregistered documents are obtained, and so long as the section 49C gives a leverage for a party to file a suit for specific performance on the basis of an unregistered agreement of sale, or even an unregistered sale deed to be construed as a contract of sale, as held in Kala Devi's case in 2010 by the Supreme Court. In fact, a principle which has been reiterated, being in force for more than a century. The point for consideration is that if you take such a stand, you should be in a position to come forward with the detail of the nature of the document you intend to execute. If it is a registered document, then the problem will be insurmountable. If it is an unregistered document, probably you can say because you have not been to the register of it, probably at your home or in a village or under a tree, you would have executed a document. And you went for a loan and the fellow has obtained an agreement of sale. And this part of the country now moving so fast, we have come across so many cases where for a loan, a party is not getting an agreement of sale any longer. He takes up a sale deed itself. And then he will cancel the sale deed once you pay the money with the interest. There was a period they took an agreement of sale for a loan, and now with all types of impediments put in the spokes of the wheel of these people to realize the loan with the exorbitant interest, they thought it would now to take a sale deed itself. Once the financial institutions have taken over the lending in all parts of the country, including remote parts, and which requires some security, there are always people to lend money to take advantage of the innocence of the parties and then to take the property itself. There, the role of a lawyer comes into play to lift the wheel, to find out what is the real nature of the transaction, whether it was a loan transaction. Normally, an agreement of sale, a major portion of the consideration is received and a small portion is left as a balance, and a larger period is stipulated as a time in the contract. I'll give you an example. Suppose an agreement of sale is for 1 crore. 90 lakhs is alleged to have been paid on the date of the agreement. And for paying 10 lakhs, they take a time of 3 years under the contract for enforcement. Then obviously, when 90% of the sale consideration has been paid, the party, if he really wants to take the property on sale, would have shelled out this 10 lakhs and got it. Therefore, this period of 3 years for paying the balance of 10% will weigh heavily against the truthfulness of the agreement of sale. The court will always, in such cases, will lean that it is more of a loan transaction. That is one part of the story. The second part of the story is the courts have also insisted upon, even though very rarely I find in a Supreme Court judgment, If you say that is a loan transaction, what the defendant has done all these years, suppose the contract in assuming for a moment a period of 1 year or 2 years is fixed in the contract, and you want to take advantage of this stating that it is a loan transaction. If I had been a judge, I would judge it from two angles. One, what is the period fixed and what is the balance consideration is to be paid. If the balance consideration to be paid is small and the period is large, it points towards a loan transaction. Two, from the angle of the defendant, if it is a loan transaction, otherwise, whether he has made any attempt to repay the money. I have rarely come across a case where a person, after executing the agreement of sale, taking a plea of loan transaction, attempting to repay the money. There lies the loophole in the law. The courts have always, if it finds that it is a loan transaction, it allows a refund and dismiss the suit for specific performance. The point for consideration is that in case of a loan transaction, the loan which has been obtained by the defendant, he should repay it. Similarly, if the court finds that the agreement is not true, and the plaintiff says that he has paid money, or the defendant says that he has paid the money, that money has to be returned, for which we don't make any leverage in the act. Therefore, when you take up a plea of non-est factum, is it requires a challenge by way of a suit, or can you take it as a defense in a suit for specific performance? Once a non-est factum is pleaded, of course subject to proof, there is no need for you to file a suit to set aside the document. Because once you say that there is a non-est factum, there was no intention to execute the document, then the document is per se void. Your void document needs to be set aside. It can be taken up as a defense in a suit or even in a collateral proceedings. The character of the document has always been dealt with by this Honorable Supreme Court in Ningawa versus Bhairappa Siddappa. Ningawa versus Bhairappa Siddappa, AR 1968 Supreme Court page 956. AR 1968 Supreme Court 956. There was a landmark judgment where the Lordship would say that if the character of the document intended to be executed is different from the document obtained, then there is a non-est factor. The document is void. A party need not challenge the document by filing the suit or to file a suit to set aside the document. The next case on that aspect, an inoperative document. A very old case was also there, Betta Perumal versus Muniandi Servai, 35 Indian Appeals 98. There is a judgment of the Privy Council. Betta Perumal versus Muniandi Servai, 35 Indian Appeal Report of page 98. There was also two other judgments. Grama Panchayat of Village Nauka versus Ujar Singh. Grama Panchayat of Village Nauka versus Ujar Singh. AAR 2000 Supreme Court 3272. AAR 2000 Supreme Court page 3272. And another judgment of His Lordship Sinha and if I remember Justice Radhakrishnan, Prem Singh versus Birpal, reported in 2006 Supreme Court. I am not having the date, but I am recollecting from memory. Prem Singh versus Birpal, 2006 Supreme Court, where this very same principle has been reiterated. In fact, in one of the judgments reported in the last month of the AAR also, there was a judgment stating that a document which is a sale deed, if you say that the document is void, it need not be set aside. Therefore, if you want to take a plea of non-est facto or a plea of fraud, undue influence, coercion, there is no need for you to file a suit separately. You can challenge it, the document, by taking up a defense. But the problem is, under the Contract Act, one of the provisions says that a document which has been obtained by fraud, undue influence, misrepresentation, mistake, etc. But misrepresentation, not mistake, misrepresentation. These are all voidable documents. It is valid till it is declared to be void. The declaration need not be by way of a separate suit. The court can always, when a defense is taken, the court can always come to a conclusion that this document was obtained under fraud or undue influence or coercion, duress, etc. Therefore, it cannot be enforced. Therefore, be sure you can take a plea as a defendant, but once you take a plea, come out with the detail about the nature of fraud, coercion, undue influence, etc. to convince the court. Then the other important factors is, normally the contract is a contract of bona fide or a uberime fide, in good faith, where a person knows a particular fact, and if he suppresses the same and enters into a contract to make huge money, then the courts have held that the purchaser or a purchaser is not entitled to specific performance. There's old judgments are available. One of them is Ramakrishna Naidu versus Pariniyappa Chettiar. Ramakrishna Naidu versus Pariniyappa Chettiar, AAR 1963, Madras, page 17. AAR 1963, Madras, page 17, where the Lordship would say that at the time of entering into a contract, the plaintiff knew that some irrigation projects is coming up in that particular area. Once that irrigation project comes up, there will be a tremendous or humongous water resource that will raise the price of the property. This factor was known to the purchaser, but not to the seller. The seller unwittingly entered into a contract. He did not foresee what will happen. The plaintiff or the purchaser foresaw that what is going to happen subsequent to the agreement. But at the time of entering the judgment, the court found that this is a special knowledge available to the purchaser. He did not disclose to the plaintiff, and therefore he tried to make a windfall, which is not possible under law. This type of agreement cannot be enforced. Now, we have got so many issues across the country where your 4-lane is late, your bus stand is coming up, an airport is coming up, then the property price will shoot up like anything. Then these are the factors which has to be taken into. And you can very well take a defense if you are cocksure that you are not aware of this. There was a rise in the price. But I'm not sure after 2018 whether such a plea can be taken as a defense. Because these types of defense, a factor which was known to the purchaser or known to the unknown to the vendor can all be fit into section 20 where it is inequitable or unfair. But once this section 20 has been taken out of the statute, thinking that this is too much of a discretion given to the court, that leverage is no longer available for the court to deny or refuse specific performance. It's quite an unfortunate situation. Even in the very wording of section 20 may not be required as outlet its utility. there should have been some discretion available to the court. Instead of tying the hands of the court that once there is an agreement and the plaintiff has proved his ready and willingness, no other option granted. An unwilling party or unwittingly a person who has entered into without knowing all these factors will be trapped. Whether there is any escape route for this type of contract. Section 16B, I'll read that section 16B, personal bars to relief. Specific performance of a contract cannot be enforced in favor of a person who has become incapable of performing or violates any essential term of the contract that on his part remains to be performed, or acts in fraud of the contract, or willfully acts in variance with, or in subversion of the relation intended to be established by the contract. There are 4 parts I will discuss. One is who has become incapable of performance, a civil death, or a person who has become insane, or incapable of executing.
Mr. Prabhkar, your window is open or how is it? The window, because a lot of crackers.
Oh my God. Bear with me for 2 minutes. I'll go to my room. Section 16B, who has become incapable of performance or violates any essential term of the contract that on his part remains to be performed, or acts in fraud of the contract, or willfully acts in variance with or in subversion of the relation intended to be established by the contract. The opening available to a defendant is this: acts in fraud of the contract. You say that if you are not aware of a particular thing which is available to the plaintiff, then you can very well explore this and say that it was in violation, or it is a fraud of the term of the contract, or willfully acts in variance or in subversion of the relation intended to be established. Subversion of the relation, how it will happen? These are things which I am pretty sure after the 2018 amendment, the court will look into in case where the court can't or should not grant a degree for specific performance. Then the court has to explore the possibility of doing it or finding the ways and means to deny the specific performance under section 16.3, which is still available, which has not been explored because of section 20 available to the defendant. Therefore, my view is, if you want to take a defense to defeat the right of the plaintiff, do it by invoking section 16B and section 16C with a ready and willingness. The next part, which I will, Damacherla Anjaneyulu versus Damacherla Venkata Sheshayya, AAR 1987, Supreme Court, page 1641. There is an interesting case where after the agreement was entered into, the defendant invested money in the property and has came out with the superstructure involving huge outgo. The court said that once this type of superstructure has been made by investing huge money, then the plaintiff is not entitled to a degree for specific performance, but is only for compensation. I doubt whether this judgment will be followed in future because we have moved. Once hardship is taken away, whether this type of intelligence is available to the court after 2018. But anyway, this 2018 amendment is subjected to whether it has got a retrospective effect or a prospective effect is still open. Therefore, all pending cases, the question of invoking section 20 will be available if you have taken a plea in the written statement. And kindly remember that once you say that the document is sham and nominal or a rank forgery, then the question of taking a plea of hardship doesn't arise. One is Leeladhar versus Vijay Kumar, AIR 2019 Supreme Court page 4652. Leeladhar versus Vijay Kumar, AIR 2019 Supreme Court page 4652, where the Lordship would say that sham and nominal and section 22, fairness will not go hand in hand. The next point is the inadequacy of consideration. This also, whether it will be available after removing section 20, I am doubtful. But the courts have said that even under the old act or the unamended act, mere inadequacy of consideration is not a bar. What is a bar is, if it is grossly inadequate, then the party cannot ask for enforcement. What is grossly inadequate? That was the discretion available to the court. Suppose you want to purchase the property by entering into a contract which is only 1/5 of the value or 1/10 of the value of the property, it can be called as a grossly inadequate. Even though the law says that merely because an inadequacy of consideration is no ground for denying specific performance, the courts have held under the unamended act, if it is grossly inadequate, then it can be denied. But whether this is open for any discussion after 2018, I am doubtful. But for the law as it existed before 2018, there is one judgment which I would like to refer. Madhusudanan versus Kerala Kumudi Private Limited. Madhusudanan versus Kerala Kumudi Private Limited. AIR 2004 Supreme Court page 909. AIR 2004 Supreme Court page 909. There was a case where there was an inadequacy of consideration. The court said that by reversing the judgment of the High Court, mere inadequacy of consideration is no ground for denying specific performance. Similarly, in the very case, the court has observed that specific performance for enforcing an agreement for partition is maintainable. In respect of immovable property, an agreement for partition, this is also possible. Have a look at section 22, specific performance with the refund, partition, possession. In fact, in the last Sunday when I took it for the plaintiff, I have suggested a person can file a suit for specific performance against X and also for partition along with that against Y and Z, who are the co-sharers along with the X. Therefore, that is possible. The next interesting point which is still available is there are two provisions. So one is section 13 and another is section 17 of the Act. Section 13 speaks about the role of the purchaser. Section 17 speaks about the role of a vendor, where there is no title in respect of the property for the purchaser, for the vendor to enter into a contract, and still he enters into a contract, whether that contract is enforceable. Section 13 would say that it gives some instances. One of them is if the vendor has subsequently acquired title to the property, or where a concurrence of other owners of the property is required, and if he can be compelled to bring them on board. 3, where the vendor agreed to sell an unencumbered property, subsequently find that was encumbrance, he can be directed to clear that encumbrance. And 4, where he sues for specific performance and the suit is dismissed on the ground of his want of title or imperfect title, the defendant has a right to return to his deposit, if any, with the interest thereon. This 4 or 13D speaks about a case where the defendant has no title. He enters into a contract, and when the court cannot give him a degree for specific performance, the court can direct the plaintiff to return the money to the defendant. Does it require any plea? The point is, therefore, under section 13, the defect in title or imperfection in title by itself may not disentitle the plaintiff or the purchaser to sue for specific performance. It is always possible for him to get a degree. I'll straight away give you a very interesting judgment which is under the old law before 1963. Baluswamy Iyer versus Lakshmana Iyer, AIR 1927, Madras, page 172, a full bench judgment. Baluswamy Iyer versus Lakshmana Iyer, AIR 1921, Madras, page 721, full bench. Where it was a case of an agreement entered into by a person who is only a co-sharer of the property. Whether this contract can be enforced or not was a question which has been posed. Whether he can be compelled to bring anybody else who are other co-sharers in the property. The court ultimately held that this is not a contract to be executed in full. If you want to execute the document or compel the party to execute a sale deed in respect of a portion of the property, then you should come to the court under the old law, because it is in 63 the part performance has changed because of these types of judgment. Under the old law, what you have to do is pay the consideration in entirety and take the share. Which a purchaser will do. Suppose he has got one of the defendant of the vendor has got only 1/4 share in the property. Under the old law, he is not entitled to sell the entire interest. But if you want to purchase, pay the entire money as agreed and take the 1/4 interest and work out your remedy by way of a partition. Yeah, judgment, which according to me is one of the reasons for amending the Act in 1963. Now, whether an undivided interest still can be a deciding factor in denying the specific performance. I'll take into account some of the judgment in the earlier class, namely Kartar Singh case in AIR 1990 Supreme Court, page 854. And then when a matter was placed before a larger bench, where 3 judges in 2005, Surinder Singh versus Kapoor Singh, discussed the issue but did not lay down the law, went on facts, and he can be directed to execute the contract in respect of his share. But subsequently, very interesting case came up. Pemada Prabhkar versus Young Men's Association, 2015, 3 SEC, page 56. Things pages 5, 5, 6 subject to correction. Pemada Prabhkar versus Young Men's Association. There were 3 vendors in the case, but only 2 of the vendors have signed the document. The court said there is a defect in title, but invoked section 17, not 13. In Baluswamy Iyer's case, the court considered that the imperfection or the defective in title and said that if the purchaser is willing to take the property with the imperfect title or defective title, then the defendant or the vendor cannot deny the execution. Therefore, if the purchaser is willing to take up the property with all the problems, he can do so. And he can also mold his relief by the 4 clauses under section 13 as I cited, that when the vendor has subsequently become the owner of the property, or if he can be compelled to bring the other co-sharers in the agreement, etc. But if it is not possible, and the court in favor of Prabhkar, instead of invoking section 13, invoked section 17 and denied the relief of specific performance on the ground that only the 2 of the vendors out of the 3 who are entitled to the property has entered into a contract, and therefore this contract is not enforceable. But quite unfortunate, in a sense, as section 17 has been invoked, section 17 does not come in the way of a purchaser. Section 17 is against a vendor. If a vendor says that I am the owner and comes to the court, if he wants a specific performance, then if he is not the owner, the court will deny the specific performance. 1 minute, I will read section 17. Contract to sell or let property by one who has no title or not specifically enforceable. A contract to sell or let any immobile property cannot be specifically enforced in favor of a vendor or a lessor. It cannot be enforced in favor of a vendor. If a vendor comes to the court by way of a suit for specific performance, may I ask me one question? There any person, a vendor comes to the court asking for specific performance, I will tell you one reason why he can come to the court. Suppose in 2018, they have entered into a contract for purchase of one property for 1 crore. Because of COVID pandemic 19, the value has come down. And now the value is only 30 lakhs. The purchaser doesn't want to purchase the property. The vendor can file a suit for specific performance, directing the plaintiff or directing the purchaser to take the property. That is possible. In such cases, when the vendor wants to enforce an agreement of sale or an agreement of or a contract, and if he has got no title to the property or absolute title to the property, the court can refuse specific performance, because this is a man who has represented that he is the owner. And this man comes to the court, and if ultimately files a suit where he has no title to the property, that property cannot be burdened on the purchaser. You can't burden a purchaser, an unwilling purchaser, to purchase a property from a person who is not the owner. Whereas, if the purchaser wants to take the property with all imperfections, he is entitled to do so under section 13. Therefore, my point for consideration is, in favor of Prabhakar's case, the court ought not have taken section 17. It is one thing to say that it is a case which can be fitted under section 13, but still section 13 doesn't deny a purchaser to purchase the property. It is all his lookout. If he is not he is willing to take the property over which the defendant or the vendor has no absolute title, it is his lookout. That is what the judgment of his lordship in the full bench, Baluswamy Iyer versus Lakshmana Iyer. Then coming to some of the minor differences, where if an agreement of sale is not on a stamp paper, the court will look into with a jaundice eye. This is not a contract. Obviously, the court will see that the parties would have filled up a document in a blank paper, signed a blank paper. Nanjappa versus Hamid, AAR 2015 Supreme Court, page 3389. Nanjappa versus Hamid, AAR 2015 Supreme Court, 3389. If an agreement of sale is not on a stamp paper, the court can refuse to enforce a specific performance. Then the court can also refuse if the original has not been filed into court. Original of the agreement of sale. In very interesting case, The plaintiff comes forward with the case that the agreement of sale was entered into by the defendant, and the defendant has taken, the vendor has taken the original. I was given only a photocopy. I am filing the photocopy. A very recent judgment in Athimuthu Manoharan versus Tilagavadi, Athimuthu Manoharan versus Tilagavadi 2021, 2 MLJ page 51. The court that the Madras High Court has held that normally, as a customary practice, the purchaser should be holding the original agreement of sale. If he makes an allegation that he is not having the original, then it is not a ground for granting a specific performance. Now coming to Article 54 of the Limitation Act. Article 54 will give you a defense. There are two types. If there is a time fixed under the contract, then the 3 years period will kick in from the day when the time stipulated in the contract lapses. If no time is fixed under the contract, from the date of refusal, the time will start. That is the second part of the article in the third column. Therefore, once there is a time stipulated, as I have said, focus on readiness and willingness. If there is no time stipulated, a person can come forward by issuing a notice demanding execution of the sale deed, and then you will say that I have come to the court immediately. Guard against that. Namely, whether this type of agreement would have been executed by a party with the full consciousness, whether you would have intended to execute such a type of contract, an open contract. There may be circumstances under which a person would have received the entire consideration and had executed an unregistered sale deed or an agreement of sale, agreeing that whenever it is demanded, I will come to the court and execute the document. Unless this is there, if the entire consideration is not paid, or at least a major portion of the consideration has not been paid, then it is a definite pointer that this agreement has to be seen with the suspicious circumstances. Take the route under section 16B to deny specific performance. Two judgments on the score. Babu Ram versus Durga Prasad. Babu Ram alias Durga Prasad versus Sri Indra Pal Singh. Babu Ram alias Durga Prasad versus Sri Indra Pal Singh. AR 1998 Supreme Court, page 3021. Where the Lordship had taken the second part of the third column. Namely, if the contract doesn't speak about any time limit and if the party refuses, then the time will start from the day when the contract was, when the enforcement was refused. Therefore, guard against it. The second part will kick in all cases where the major portion of the consideration is paid or the entire consideration has been paid. Then see with the links or a magnifying glass whether this consideration has really been passed. If it is not so, attack the agreement that the consideration has not been paid as stated in the agreement. Then allow the plaintiff to prove that the consideration has passed as stated in the agreement. Last of the point is whether the contract which is vague can be enforceable. Not in all circumstances, a vague contract cannot be enforced. Sometimes the contract will be vague with regard to price. Contract will be vague with regard to the property. If the vagueness is or the indefinite uncertainty is with regard to the property, it is always possible for the party to bring in evidence or a collateral evidence to show that the parties are really intended to enter into a contract in respect of this property. In many a case, in a village, the property will have a name. A name would have been incorporated in the agreement rather than the survey number or extent. That can be established. Guard against it. Or if the price has not been fixed, then the question of enforcing such a contract does not arise. Straight away, there are two judgments. One is Panni Selvam versus Baylis, AR 2006, Madras, page 242. Ascertaining property can be made by other evidences. AIR 2006, Madras, page 242. But another judgment of the very same High Court in AIR 1927, Madras, page 513. 1927, AIR Madras, page 513. Secretary of State versus Wolcott Brothers. That was a case where rate could not be ascertained. The price could not be ascertained. The consideration could not be ascertained. If the consideration cannot be ascertained, then this type of agreement cannot be enforced. The last of them, a repudiation of the contract within a stipulated time. What will be the consequences? Suppose the contract says within 3 months, you have to enforce. And one of the party within the period of 3 months says that the contract is bogus. And as a defendant, you take a stand at the time of giving a reply or something like that, your party says that the contract is bogus, fraudulent. Can a purchaser within that stipulated time come forward with a suit for specific performance or not? In such cases, the remedy available for a purchaser immediately is to file a suit for compensation. Or still, if he wants to come forward with a suit for specific performance, he has to wait for the period contemplated of the contract to lapse and then to file a suit. But beware, in such cases, the readiness and willingness has to be proved by the plaintiff. Straight away, an interesting judgment. Jawaharlal Wadhwa versus Hari Prasad Chakrabarti. Jawaharlal Wadhwa versus Hari Prasad Chakrabarti, 1989, 1 SEC, page 76. 1989, 1 SEC, page 76. Yeah, 3 judges of the Honorable Supreme Court came to the conclusion that once there is a repudiation of the contract within the stipulated time, the only remedy available to the purchaser is to file a suit for compensation. But if you want a specific performance, wait for the period stipulated to lapse and then file a suit for specific performance. If he opts for the second course, then he must prove his ready and willingness. Therefore, in such cases, what is the option available for a defendant? He can always come to the court and say, I have repudiated the contract 2 months before. He never exhibited any willingness. How this willingness can be done after the repudiation? Immediately deposit the money or send the money balance consideration or say that I am ready, money is available with my bank, etc. These types of ready and willingness should be pleaded by the plaintiff and proved. This is the loophole which will be available to the defendant from the date of repudiation to the date of the filing of the suit. The readiness can be challenged. Ultimately, the refund of the compensation which has been sought under section 22 or 21, which has to be considered by the courts, read with the section 19. My point is, in all cases where the party seeks a compensation, he can seek a compensation under section 20 in 2 cases, 2 instances where if the court designed the specific 22, the court decided that the specific performance ought not to be granted. But there is a contract between the parties which has been broken by the defendant. Then the plaintiff is entitled to compensation for the breach and award him such a compensation. This will fit in cases where the plaintiff is, as a purchaser, not ready and willing to perform his part of the contract. The contract is enforceable, but the section 22 says where the defendant has broken the promise. Only in such cases that compensation is contemplated as section 21(2). Therefore, take advantage. Namely, I have already broken the contract or repudiated the contract, and then therefore the plaintiff is entitled to only compensation under section 21(2) of the Act. Any such a suit, the court decides that the specific performance ought not to be granted. I say that this 21 originally has to be read with the section 20 and section 16C, readiness and willingness and hardship. But once the hardship has gone, this 20 subclass 2 has to be read only with the section 16.3 of the Act. 21.3 says, if any such as the court decides a specific performance ought to be granted, but that is not sufficient to satisfy. Mere specific performance, in some cases, it is not in respect of an immovable property. In some other cases, where in a case of a work contract, etc., the specific performance may not be enough, the compensation can be granted. But beware, always section 21, subclass 2, will give you a leverage that once there is a repudiation of the contract, the defendant can take a plea or a shelter under section 20, subclass 2. As a defendant, whether you are a plaintiff or a defendant, it doesn't matter. The point is, come to the court with the fairness, honesty, and integrity. And if you place a case fairly before the court, instead of shooting multiple defenses, namely that the agreement is not true, I have received money as a loan transaction. These types of pleas always unsettle the court. The court will not favor a party who comes to the court not with any truthfulness. This entire specific relief act is based upon fairness and lack of arbitrariness. If fairness is there, then there is a possibility. Then moving forward, whether this amendment 2018 is enough, it is now loaded in favor of the plaintiff, namely the purchaser. Once there is an agreement, and if this agreement is true, if the party is ready and willing, grant him a degree. Whatever the hardship which the defendant will undergo, the vendor will undergo, it has all vanished. Whether this amendment is correct, my view is that it is in an overzealous enthusiasm that this discretion has to be curtailed. The legislature of the parliament has come with this off-baked amendment in 2018. Instead, what it should have done is, it should have balanced between the vendor as well as the purchaser. How it could have been done? This 3-year period for enforcing the specific performance should have been reduced, namely even 6 months, where they can say a party who has approved an agreement of sale comes to the court within 6 months. He is entitled to a specific performance, otherwise he is not entitled to any specific performance. The period should have been reduced. Then there is no need for us to go into the question of readiness and willingness at all. Once the period is reduced, this ready and willingness or unpredictableness in a court of law could have been reduced. That would have been the direction in enacting this. Once this hardship is removed, the court should have removed this long period of wait. Second, section 55 with regard to time is not the essence of the contract in respect of an immovable property. Why, when this amendment has been made, as Lordship Ravindran made a hue and cry in 2011 that this should have been, the Parliament should have a relook on the whole procedure. They should have done it. If the period is reduced and there is no need for a party to prove ready and willingness, give a sanctity to the contract. Once you enter into a contract, and third, remove that 49C. In many of the cases, the registration in respect of an agreement of sale has been made compulsory, but 49C gives them the room for filing a suit for specific performance, and the basis that this is can be used as an evidence of a contract in a suit for specific performance. In 2001, 48 of 2001, Arun Jaitley amendment came, 53A was removed for in the case of an unregistered document. And at that time, it was thought that the agreement of sale, if a compulsorily registrable is made, many of the innocent people living in the rural areas will be affected. Now 21 years have passed. Now time for us to remove that imbroglio under section 49C. Have an agreement of sale, register it, file it within 6 months, get a degree, or otherwise forget it. Truth always triumphs, not necessarily in a court of law. Thank you.
Yeah, I'm just saying as to whether we have any questions. If the purchaser, the plaintiff says the sale agreement entered as a fraud and files specific performance on the basis of oral agreement, what is the stand?
There can't be two agreements. One, either you stick on to one. As a plaintiff, you can't take two pleas. It cannot be an alternative plea, because once there is a agreement, you say that it is a fraud, then the execution is admitted. Then the question of falling upon an oral contract doesn't arise. Once there is an agreement and all the terms are reduced into writing, and if you say that it is a fraud, if it is established fraud, then it goes. If the fraud is not there, that agreement has to be enforced. The question of disowning the contract and falling upon the original oral contract doesn't arise. It is not possible.
Fraud vitiates everything, and then you say that both cannot sink and swim together.
Yeah, yes.
So Harsha says, what is the difference between an advance money and an earnest money?
Earnest money is for the performance. That if you doesn't go through the contract, then you will lose that money. Advance may be a part of the consideration itself. Advance is a part of the consideration, whereas earnest money is a money which is paid for due performance of your obligation under the contract. It need not be part of the consideration.
So one is a part of it, the other part may not overlap into it.
Yeah.
Pradeep Kumar, majority of the agreement of the sale at the time of giving advance, not registered. To register, the true amount is to be shown, and accordingly stamp duties to be paid. And so to avoid the payment at the time of giving advance agreements would be an unregistered. So for specific performance of sale, what can be done? All the details will be given in the agreement, but it will be normally on rupees 200 stamp paper. Buyer does not insist it should be for registration. Under what circumstances and what is the remedy?
That's I have advocated that if your 49C is removed from the statute book, there are two things available under 49C. One is with regard to a document which it requires registration not registered. It can be used in a suit for specific performance, and another collateral purpose. Once this is removed, there is no point in having an agreement and not being presented in court. This type of agreement are entered into by the parties to generate, I would say, the difference between the money which has been paid and the money to be accounted for. In cases where the circle rate is less than the market value, the parties intend to go for an unregistered agreement by putting the market value and subsequently paying the money under the circle rate in respect of registration. That can be reduced if you remove this clause for enforceability. Once it is done, the question of having an unregistered document is of no use.
What is the difference between a registered and a non-registered will? In case of an immovable property, sir, can a person who can't go to the sub-registrar office due to some problem, is it a valid or not valid? In case of will, if the will can be challenged or not if it is not registered?
In case of a will, there is no difference, except for the fact that under Section 60 of the Registration Act, the registration lends some authenticity. There is a presumption with regard to due execution. But always in cases of a will, mere execution is not enough. you have to prove that the testator was in a sound disposing state of mind, and the attesting witnesses are attested. These things cannot be presumed. Therefore, except for this purpose of some authenticity, the registration may not have any effect in case of a will. But your question with regard to the subrogation of it due to some problem is valid or not valid. Yeah, unregistered will is valid provided it has been attested by two witnesses. Always kindly remember that even though the will doesn't require registration, the courts of law are very, very reluctant to uphold a will which is unregistered, and if it is draws some suspicious circumstances where the legal heirs have been disinherited, some third party has been given a property, huge property, not making any provision for the daughter, son, wife, etc. And if it is an unregistered will, it will be very, very difficult to prove in a court, even if the witness speaks the truth.
When vendor returns the check given in lieu of advance amount of agreement and denies to execute the sale deed, what is the best remedy for the purchaser? For compensation or specific performance? The reason at the background is the rise in the value.
It is always a choice available, but the point is if you go for a compensation, when you will go for a compensation? Compensation in respect of an immovable property is not in addition to. If it is a work contract, then it can be in addition to. But always it is preferable to go for a specific performance and in the alternative for compensation.
Because normally people ask, do we go for a specific prayer or we should always go for an alternative prayer?
Yeah, alternative prayer is a better. Because law says that if the alternative prayer is not there, then the court cannot grant compensation or even refund. Even though some of the courts have stretched the principle of equity, very recently His Lordship Nageswara came to him heavily, the last of his judgment, where he said that the compensation cannot be awarded because there is a special provision which says there should be a specific prayer with regard to compensation.
Okay, next is, if plaintiff says fraud and never entered the sale agreement, will the stand on oral agreement continue?
I don't think so. I'm not sure which plaintiff will come to the court as a fraud and they never entered the sale agreement, and we would say there is an oral agreement. I can visualize only one thing. The purchaser, having entered into an agreement of sale, subsequently wants to disown that and enter and fall back upon an oral agreement if the oral agreement is more beneficial to him than the written contract. When it will be beneficial to him, it will be beneficial to him provided the value in the oral contract is far less. Is it possible for you to prove such an oral contract? Leave alone the question of filing a suit. When there is a written contract, can there be an oral contract inconsistent with the terms of the contract? Section 92 will be a bar. Then the last of the question is, there is a family settlement instead of will. Is it valid or not? I think I'm not sure about the circumstances in which it has been asked for, but family settlement is different from a will. Family settlement is a settlement in which consensus is arrived at by all the parties, all the members of the family. And it can be either registered, or if it is a memorandum of recording a past transaction, it does not even require registration. A family settlement always be looked upon by the court favorably because it amicably settles all the issues between the members of the family. Will come into effect on the demise of a testator in respect of his absolute property. A family settlement is in respect of all the properties of the family, whether it is of the testator or not. Therefore, both of them operates on a different field. A family arrangement or a settlement or if you say that it is a settlement, the settlement of what I can visualize from this question is, a testator, instead of writing a will, can he execute a settlement deed? A settlement deed will come into operation immediately, whereas the will come into effect after the demise of the testator. It all depends upon the wish of the person, whether he wants to hold the property till his lifetime or he wants to give it now. But both are valid provided the executant is entitled to execute the document. Namely, he should be the absolute owner thereof. Then whether it is a will or a family settlement, both of them are valid.
Yeah. So these were all questions, Mr. Prabhkar. As usual, everybody was glued to the seat to understand the nuances of law. So thank you, everyone. Stay safe, stay blessed, and we will keep on sharing the webinar links. Do stay connected with us. And those who have missed the previous webinars, they can share, like, and subscribe to the Beyond Law CLC YouTube channel. Thank you, everyone.